A warm welcome to lesson number 35 in our 50-part series on the law of evidence. In the previous lesson, lesson 34, we saw sections 56 and 57 as a part of chapter 3, which talks about facts which need not be proved. In today's lesson, we will have a look at section 58. Since section 58 lies in chapter 3, it will obviously talk about something that need not be proved, and section 58 tells us that facts admitted need not be proved. We've learnt this fact as a very important principle of the law of evidence. If you remember, we've always discussed that evidence is required to be given only if the fact is disputed, right? Which means that the fact is such that it has been alleged by one and then it has been denied by the other. That is when there's a dispute, and that is when there is a need for evidence. In case the fact has been admitted, then there is no need for proof, which means there is no need for evidence to be given. But before proceeding any further, it's important for me to remind you this point. The point being that the word admission or admit or admitted is used in two distinct senses in the Indian Evidence Act. Both of these meanings, they have the same spelling. However, they convey very different meanings. The first meaning, of course, is when you say that there's an admit card. What is the meaning of admit card? It means that you were allowed entry. Likewise, when you say I got admission into university, it means you got entry into it. When you say evidence was admitted, it means the evidence was considered admissible, right? And therefore the court could admit the evidence. That's the first meaning of admit. The second meaning of admit is kind of like conceding that you have done some wrong, where you make a self-harming statement. Okay. Here, this is section 58 and it is in accordance with the second meaning. Facts admitted need not be proved, which means that if a person makes an admission about a certain fact, which means that let us say there are two parties, A and B. Okay. Now A makes a certain statement and B, instead of challenging it, that's what we'd expect, that B would challenge it. But let us say B, instead of challenging it, B really accepts it. So B says yes, okay, B admits it, which means both A and B are basically in the same direction. Okay, and facts that are admitted need not be proved because B has admitted what A has said, which means it is a fact that has been alleged by one and admitted by the other. There is no dispute, and hence there is no need for evidence. Like we saw even in the previous lesson, ordinarily, the court requires a fact to be proved, which means it does not simply believe what has been said. It requires evidence, and then once evidence has been given, the fact could be proved, and then the court believes that the fact exists, right? We'd also seen the very important fact in the previous lesson, and we will see as to why it is so important now as well, that this fact should be relevant. If the fact itself is not relevant, then well, whether it is admitted by one, denied by the other, or admitted by whatever, that becomes absolutely immaterial because first we have to see the relevancy of fact. That's why chronologically you find that in chapter 2 and now we are in chapter 3, right? So what you find in chapter 2, which deals with relevancy, always has to be borne in mind, and let me show you why. Look at section 23. It talks about admissions in civil cases when relevant, and it also tells you as to when it is not relevant. So it says that in civil cases, no admission is relevant if it is made upon an express condition that evidence of it is not to be given, or the court can infer that the parties had agreed that it should not be given. Okay. So let us say there's a certain kind of admission. Okay. Admissions in some cases are relevant, in some cases they are not relevant. Okay. So if an admission is not relevant, then the court does not even listen to it. Right? The court says, let's not talk about this. If it is relevant, right, a fact which has been admitted, this need not be proved. So when we talk about admissions, we are talking about relevant admissions. And as you can see here in section 23, it talks about some cases in which the admissions are not even relevant, right? So let us say in a civil matter, as you know, admissions can be for both civil as well as criminal, right? So let us say in a civil matter, two people had decided that, okay, we will not give evidence for this, okay? Then the court will not accept any admissions relating to that because you have a provision in chapter 2 that says that this is not relevant at all. So always remember that relevancy will be spoken of first and then we look at the later rules. So now you can have a look at section 58 in some detail. You can in fact pause the video and read this by your own self. As you can see, it's quite long and therefore it will require you to pay around 2 or 3 minutes of attention for you to be able to gather the meaning of what is contained in section 58. So, section 58, breaking it down, talks about first, no fact needs to be proved if the parties have agreed. So, let's say you had two parties A and B. Now, either they agree at the hearing or they have agreed before the hearing in writing, right? So, if two people have agreed upon a certain fact, right, then that need not be proved, which means no evidence is needed for a fact that they agree to. That's simple. Moving on, it says or by any rule of pleading in force at the time, which means that there is a certain rule relating to pleading because of which evidence is not needed because it has been admitted. Are you aware of what pleadings are? You see, pleadings basically relate to the plaint which is given by the plaintiff and the written statement which is given by the defendant. So there are some important rules. For example, when you talk of Order 8, Rule 5, okay, Order 8, Rule 5 again deals with the written statement. So there's a rule relating to the pleadings, and that is that if there is a fact which has not been denied in the written statement, then it is deemed to be admitted. Let me explain this to you. So basically, let us say there is a plaint and then there's a written statement. So what does the plaint and the written statement basically do? It gives you the facts, right? The material facts. So let us say this is the plaint. So in the plaint, it is given that, let's say this is A, plaintiff, and B is the defendant who writes his written statement. So A says that maybe B took 500 rupees from him, that he also did not give him the land, and he says many things. Now, in the written statement, which is basically the response, B is required to either accept or deny what has been said here. Now, let us say there was one thing said here, maybe about land. Okay. And here in the written statement, the defendant does not deny. He doesn't accept, but he doesn't deny. He forgets to deny maybe. Then by the rule that is contained in Order 8, Rule 5, he is deemed to have accepted it. He is deemed to have admitted it. So that means it is an admission because he has admitted what has been said by the other. That means there is no dispute. It means that evidence is not needed and therefore that fact need not be proved. Right? You can also see that there's a similar rule under Order 12, Rule 2A, which actually deals with admissions. So Order 12 deals with admissions. If you want, you can go and have a look at it as well under the CPC. Now, you can look at the proviso to this section. It says, provided that the court may in its discretion require the facts admitted to be proved otherwise than as admissions. So as you know, when you say to be proved as an admission, it is basically talking about the part that we saw from 17 to 31. But we also saw that a certain fact, we've seen many examples of this, that a fact could be relevant either as an admission or it could be relevant under some other section as well, right? So the proviso here says that we've seen that if the fact is relevant as an admission, then it means no evidence can be taken. That's what basically section 58 is saying. If a fact is an admission, right, if the fact has been admitted, then there is no need for evidence. However, if it is to be proved otherwise than as an admission, then evidence can be taken. That's what the proviso tells you. So now that we have understood this point as to what section 58 deals with, let me ask you a question. Let us say there's a fact that has been said by A, okay, and B accepts that fact, which means both of them agree, and B has admitted what has been said by A. Now, does this fact become final? Is that conclusive? What is the evidentiary value of any such admission that has been made? And with this, we recollect one very important provision that we'd studied when we were dealing with admissions, Section 31. Section 31 of the Indian Evidence Act tells you that the evidentiary value of an admission is such that it operates only as an estoppel, and it also says that it is not conclusive proof, right? So with this, as you could see, we've seen that the provisions from 17 to 31, and we've spoken about section 23 as well in particular here, required to be read along with section 58, and then you get an idea of the fact that facts admitted need not be proved. Okay, so I hope that this lesson was of some use to you. Thank you so much for your patience. Good day.